What happens if you don't show up for your deposition in your medical malpractice case here in New York? You want to know what happens? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. All right, if you don't show up for your deposition, a number of things are going to happen. The first thing that's going to happen is the defense lawyer is going to ask, hey, where's your client? Why isn't he here? Now, if he doesn't have a good answer, they are going to break up that deposition, and now the defense lawyer is going to do a number of things. The first thing he's likely going to do is write to the judge in a formal request known as a motion and say, hey, judge, the injured patient who brought this lawsuit failed to show up for his question and answer session. And now we are prejudiced. We can't defend this case if they don't show up and allow us to question them. Now, what's the judge going to do? The judge is going to turn to your lawyer and say, counselor, where was your client? Now, assuming you don't have a good valid reason for why your client was not there, even though this had already been scheduled and set up and confirmed by all parties, by all the people involved, now you've got a problem. There's a good chance the judge is going to give you one more chance, or I should say give your client one more chance, the injured patient. Say, listen, I want you to schedule the deposition, the pretrial question and answer session again, and if they fail to show up, now, here's what's going to happen. So let's say the parties now reschedule, and on the appointed day, your client, the injured patient, again fails to show up. What happens then? Now, in all likelihood, the defense is going to ask the judge to throw your case out. Why? Because the defense will not have had an opportunity to learn in your own words exactly what happened. The defense will not have an opportunity to lock you into your testimony. This is pretrial testimony that carries the same exact weight as if you are testifying at the time of trial. The only real difference is it's taking place in your attorney's conference room. There's no judge present. There's no jury present. The defense lawyer is there. Your attorney is there. You should be there. And now there is a court reporter there to record all of the questions being asked and all of your answers. At the end of that pretrial question and answer session, the court reporter goes ahead and transcribes all of those questions and answers, puts it into a booklet called a transcript. And that forms the basis of your pretrial testimony. And by the way, that can be used against you at the time of trial if your answers at the time of trial are different than what you have answered during your pretrial question and answer session. So, what happens at that point? Well, at that point, the judge will turn to your attorney and say, counselor, where was your client? Judge, and now he's got to give some reasonable excuse about why you, the injured patient, did not show up. And if the judge feels that that's a nonsense excuse, there is the very good possibility that the judge will dismiss your case. Why? Because you have failed to cooperate and show up for a required questioning session known as a deposition. And lawyers like to call this also an examination before trial, but it's the same exact thing. It's a question and answer session given under oath in your attorney's office. Why do I share this information with you? I share it with you because this question comes up often when an injured patient turns around and says, listen, I really don't feel well. Do I have to show up? Do I have to come to your office? Do I have to sit there for hours and hours being bombarded with questions from the defense attorney? And the answer is yes, you do. Because now you have put your condition in issue. And now the defense has a legal opportunity to go ahead and ask you, hey, Mrs. Jones, tell us what happened. What did you do next? What conversations did you have with the doctor? And how did you follow through? Did you return? And what problems do you have today? And what things are you no longer able to do today because of what this doctor did? And it gives you an opportunity to go ahead and explain, to educate the defense attorney about what this case really is all about and what problems you have because of his client's carelessness. You know, I recognize that you have questions or concerns about your own problem. Well, if your problem did happen here in New York and you have not yet started a lawsuit and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, @oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day.